So yeah, so we discussed the other day that okay, words are to be given their natural meaning. Okay, if the common meaning does not admit exclusion or inclusion of anything, of if it is not explicitly included or excluded, then we are not to judges are not to include or exclude something which is not allowed by the words. Okay, so that's what we studied. Apart from that, uh, okay. So I think this is broadly what we covered the other day. Or did we cover anything else? Yeah. Then one more thing that we discussed was that if a particular word has a technical meaning, okay, if it has acquired one, and if the legislation deals with particular specific area, specific trade, commerce, etc., in such case judges are to give technical meanings, their technical words, their technical meanings. Okay, so this is the rule that we discussed so far. So today, uh, important part of that definition that we are going to discuss is omissions are not to be inferred. Okay, so judges are not to assume that well something has been omitted. Okay, so it has been said that words cannot be read into the act of parliament unless clear reason for it is to be found within the four corners of the act itself. Okay, so what is there is what is to be read. Okay, so you cannot include something which is not there. Okay, so you cannot read words into a particular act of parliament. Okay, unless clear reason. Okay, so that's the further room which has been given to the judges. Okay, unless clear reason for it is to be found within the four corners of the act itself. Okay, so that you can do, but not at the very first instance. Okay, so if the judge thinks that well not including this would lead to some complete absurdity, okay, it could not have been done, okay, in extreme cases, okay, only then, okay, but then it has to be allowed within the four corners of the act itself. Now what is four corners of the act? There is another rule that we are going to study later that says statutes are to be read as a whole. Okay, so you are not to read a particular portion of the statute and then arrive at a meaning. So you have to read the statute as a whole. So that's another rule that we are going to look at later on. Now if that allows, only then the same can be done. Okay, so in an important case by the name Lloyd Bank versus Elliott, 1947. Just a second, I will put it here. Okay, this is the case. Lloyd's Bank versus Elliott. Okay, it was said a case not provided for in a statute. Okay, a case not provided for in a statute is not to be dealt with merely because there seems to be no good reason why it should have been omitted. So you are not to infer omission that you. So if it is not there, you are to assume that well it has been deliberately, it has been consciously omitted. Okay, so that's what has been said. If you are a judge, you are not to assume that well this omission might have been by mistake. That's not what you are to do. Okay, so that's what is said. A case not provided for in a statute is not to be dealt with merely because there seems to be no good reason why it should have been omitted, and the omission appears in consequence to have been unintentional. So this is what the judges are not to assume. Okay, that should not be the first instinct of the judge. Okay, similarly in R versus Ellis, okay, you will see how this rule has been applied in this particular case. In this case, I will just quickly type case here. Okay, R versus Ellis, 1844. In this particular case, there was an act, okay, that authorized removal of lunatics to a hospital when there was no lunatic asylum, okay, established in the country. Okay, so it clearly says that it authorized removal of lunatics only when there is to another hospital, to a hospital, okay, when there is no lunatic asylum established in the country. in the county. Okay, now what if there existed an asylum but it is full? Okay, would that be reason for such authorization for removal? It was held no, that cannot be, because that is not explicitly said anywhere. Okay, so if that's the case, then you are not to assume omission on the part of the legislature. So that's what has been held in this particular case. Although you see that the outcome seems to be problematic, isn't it? It's full and still it does not authorize removal. Okay, well, in the light of the facts, in the light of the requirement of the act that says that it authorized removal of lunatics to a hospital when there is no lunatic asylum, but here you have a lunatic asylum but it was full, so you cannot assume that there is no lunatic asylum, and hence removal is not justified. So that's the rigor, that's the strictness of the application of this rule. Okay, it says that omissions not to be inferred. Another important case, okay, that just a second, I will put it there, is okay, it's by the name IRC versus Section Lilly and Skinner. Okay, in this particular case, there was an Income Tax Act 1952. We are concerned about a particular provision. You don't need to remember the exact provision, do not worry. It's section 271(1)(d)(3), okay, that defines industrial buildings. Okay, this particular provision defined industrial buildings, okay, as inter alia one used for the purposes of trade. Okay, so how is it defined industrial building? One used for the purposes of trade, which consists in the storage of goods which, having been manufactured, have not yet been delivered to any purchaser. So the essence here is that industrial buildings, one used for the purposes of trade. That's what the definition says. Okay, the Crown had submitted that in use for the purposes of a trade, okay, in use for the purposes of trade that we are concerned about, meant wholly or mainly in use for such purposes. Okay, now it doesn't say anywhere that it means wholly or mainly in purposes, so it could be partially in purposes, okay, as you will read. But the Crown submitted that no, in use for the purposes of trade should mean wholly or mainly in use for such purposes. Okay, so what was held in this particular case? Lord Reed had held that, but that involves, if we were to go by the Crown's submission, that would involve writing words which are not there, and I can see nothing in the context to make that necessary. Okay, so that's what Lord Reed had said. So it was said that the word used here, okay, is not qualified in any way, as the definition says. You don't see any qualification in the definition. Okay, so the word used is not qualified in any way. If the intent of the legislature had been to restrict the right to the allowance to the owner, occupier, etc., okay, this word would have been properly qualified, but it's in no way qualified in the definition that we just read. Okay, so as it is, the word is not qualified in any way. So Lord Reed held that which is not written there in the statute, we are not to assume that. Okay, so the in this particular judgment, the submission of the Crown was not accepted. Okay, so are you guys with me till now?
Yes, sir.
Yes,
okay,
sir. Yes, sir.
It's very simple. Nothing complicated. Okay, so don't worry about the exact provisions. You don't need to remember either. As long as you remember the ratio held in these cases, that will suffice. Okay, another important, it's aspect of the same rule. Okay, every word in a statute to be given a meaning. So no word is to be ignored. Okay, if you go by plain meaning, if you go by grammatical rule, okay, it does not allow you to ignore a particular word, okay, ignore a particular expression. So the rule requires that every word in a statute is to be given meaning. Okay, every single word that's there is to be considered as the intention of the legislature. So in Salmon versus Duncombe, just type it there, just a second. So in this particular case, Salmon versus Duncombe, it was said that a construction which would leave without effect any part of the language of a statute will normally be rejected. So remember, you are not to assume omission. In the same way, you are not to exclude anything. So that's what the rule is. Okay, every word in a statute is to be given a meaning. Okay, so these two are very related. A construction which should leave without effect any part of the language of the statute will normally be rejected. Okay, so it's said that normally, so there is a possibility of a situation where it may be rejected. So we'll discuss that later on. Okay, so we have a important case here. Okay, by the name Dinesh Chandra Jamnadas Gandhi versus State of Gujarat. I will type it there so that you can. These cases are available on the website. Okay, so you will find it easily. So this case, okay, by the name Dinesh Chandra Jamnadas Gandhi versus State of Gujarat. Okay, so in this particular case, we are concerned about a particular act, okay, known as Kerala Food. Sorry. This is next name is it's Prevention of Food Adulteration Rules 1955. So we are concerned with Prevention of Food Adulteration Rules 1955. Okay, and under Rule number 29F. Okay, under Rule number 29F of Prevention of Food Adulteration Rules 1955. And what does it say? Okay, so the question, it talks about fruit product. Okay, so don't don't worry about the entire rule. Okay, it talks about fruit product. Okay, if it is a fruit product, then certain standards are to be applied. Okay, if it is a fruit product, okay, that's the question that we are struggling with. Now the question is whether supari, okay, or betel nut, okay, whether that will come within the meaning of fruit product. So these are application of the rule, okay, not the immediate, aspect of the rule that we discussed, okay. So the question is whether supari or betel nut will come within the meaning of this word, okay, expression called fruit product. What will be your answer to that question? Will betel nut and supari come within the meaning of fruit product? Are you guys there? Hello?
Yes, sir.
What do you think? Do you think betel nut or supari will come within the meaning of fruit product in this particular rule that I just told you about? Either say yes or no.
No, sir.
No, sir.
Okay. Why do you think so? It's a fruit, isn't it? I mean, betel nut, coconut.
It goes on a tree. There's no nutritive value or something.
The nutritive value that does not really matter, does it? I mean, many fruits do not have nutritional value. I mean, they differ in their nutritional value.
So if we go by plain meaning, then definitely it is a fruit.
Yeah, but then remember that in a certain context, okay, you are to assume that specific meaning first. So we are dealing with what? Prevention of Food Adulteration Rule, okay? So when it talks about fruit product, it's referring to a different kind of fruit product, okay? Supari and betel nut do not, see, that's what we are trying to discuss this whole time, okay? So in this particular case, they held that supari or betel nut, though derived and prepared out of the usufruct of Areca palm tree, so normally you would assume that this is a particular case of, fruit, okay? And supari, when it is cut and dried, you'll say that, well, it's a fruit product, okay? It was held that it is not for that reason fruit product within the meaning of Rule 29F of the said, Rules 1955, okay? So the Supreme Court had in this particular case referred to the rule that it is not the technical or scientific sense, okay, but the sense as understood in common parlance that generally matters in construing statutes, okay? So as you see in this particular case, you are not to go by whether scientifically it comes within the meaning of fruit or not. Obviously, it does come within the meaning of fruit if you go by such scientific definition. Okay, but that's not what we are concerned about in this particular case. Okay, what are we going to see in common parlance, see in our lay understanding, okay, as we understand the word, okay, we don't think that supari, betel nut come within the range of the same kind of fruit product as we normally consider to be fruit product. That's clearly the case. So it was based on this reason it was held that, well, no, supari and betel nut would not come within the meaning of this term called fruit product. So you see how it has been applied. But now think about this, okay, this rule being a kind of very specific scientific technical legislation, okay. In that situation again, if it were like that, then you have to go by those specific and technical meaning, okay. However, if there is a meaning that it has acquired in a particular trade, practice, etc., okay, and the legislation addresses those specific trade practices, then again you do not go with scientific definition, but the meaning it has, that specific meaning that it has acquired in that particular trade and business, etc. So that's how it is to be done. So are you guys with me so far?
Sir.
Yes, sir.
Yes. Priyadarshi?
Sir, yes, sir.
Yes. Okay, so that's how it has been interpreted. Okay, so we have another important case, okay, by the name Forest Range Officer versus Khushbu Enterprises, 1984. Just a second. Okay, Forest Range Officer versus Khushbu Enterprises, 1984. So in this particular case, we are concerned with Section 2F of Kerala Forest Act, okay, that defines, so this particular act defines forest produce, okay, and how does it define forest produce? So it says the following, whether found in or brought from a forest or not, that is to say, timber, charcoal, wood oil, gum, resin, etc., 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 okay. The question that we are concerned here is whether sandalwood oil, okay, sandalwood oil, okay, would come within the meaning of wood oil, okay. Now in this particular case, what had happened was, it was argued that there is a very technical process of extracting wood oil, okay. Well, sandalwood oil, okay, has a different way of extracting, okay. So there is a different way of extracting sandalwood oil, so it should not come within the meaning of wood oil as you see in this particular definition, and hence it was argued that, well, sandalwood oil not fall within the purview of this particular act, okay. So what had happened in this particular case, I'm referring to this particular book, okay. The question in a case, okay, before the Supreme Court was whether sandalwood oil is wood oil as used in the above definition that I just read out to you. Okay, the sandalwood oil is produced at a factory level by mechanized process utilizing the hard wood and also roots of sandalwood. Okay, trees removed from the forest as a raw material. The argument before the Supreme Court by referring to the technical dictionaries, so they had referred to technical dictionaries, was that wood oil is a natural produce of the forest derived as an exudation from living trees in the forest belonging to the family of whatever, unpronounceable word, okay, Dipterocarpuco, I don't know how to pronounce, sorry, okay, bear with me, some specific group of trees, okay. And it will not include sandalwood oil, which is a byproduct from the sandalwood by industrial process. So they were giving a very technical definition of what should come within the meaning of wood oil. Okay, so this argument was rejected. Okay, the above argument was not accepted. It was pointed out that the object of the act was to conserve forest. Okay, as the name itself suggests. Okay, the conserved forest. Okay, well, and there was no indication in the act to exclude what was ordinarily and in common parlance spoken of as wood oil. Okay, so this is how it has been held. Okay, so are you guys with me? So the fact that the process of extraction of
Yes, sir.
sandalwood oil is not as sophisticated as you technically understand as wood oil, that in itself would not be a reason enough for us to exclude that from the purview of the application of the said provision. So that was what was held in this particular case. Okay. So
Yes,
you
sir.
have to look at the context in each specific case. So this rule, although seems very easy, not really when you look into it. But you will, as a judge, know when what is the right interpretation in specific cases. Okay. Another important case that we are going to discuss is by the name Ramavatar versus Assistant Sales Tax Officer. Okay. So this is the case, as you can see here. So what had happened in this particular case? The question that was involved in this particular case was whether sale of betel leaves, okay, whether sale of betel leaves was subject to sales tax. Okay, this is the question that court needed to determine whether the sale of betel leaves was subject to sales tax. Okay, the appellant contended that betel leaves were vegetables and so can't be taxed. Okay, so it was a claim of the appellant that betel leaves, okay, pan, were vegetables, so can't be taxed. Okay, so what do you think the court might have held in this particular case? Make a guess here.
So not exempt from taxation.
So you're saying that it is to be considered as vegetables.
It is taxable, I think.
So in this particular case, okay, it was held that although the word in natural history, okay, this word, okay, in natural history and according to dictionary meaning is comprehensive enough, okay, to include betel leaves, okay, vegetable, clearly betel leaves, okay, if you go by technical, okay, meaning, okay, the court held that being a word of everyday use, it must be construed in its popular sense, okay, meaning that sense which people conversant with the subject matter with which the statute is dealing would attribute to it, and clearly betel leaves will not come within the purview of meaning of vegetable. So got it?
Yes, sir.
Yes, sir.
Yes, sir.
Yes, sir.
Yes, sir.
So why? The reason is simple. See, when we talk about vegetable, we assume that this is something that you grow in your kitchen garden, and this is not, this is betel leaves clearly do not come within the meaning of that. So you do not go by scientific meaning. Okay, will this come within the meaning of the word vegetable? Well, you can say so, but then and humans consume it as well. Okay, but then we do not use betel leaf in the common lay person's perception. We do not use it in the same way as we use the word vegetables. Okay, so that's what the court had held. Okay, so you have to go by the common understanding of the word. Okay, so we have another case by the name Municipal Board versus State Transport Authority, Rajasthan, 1965. Just a second. There are many other cases. These are not the only cases. Okay, I'm just giving you examples of certain cases. The rule, as long as you remember the rule, that should suffice. Okay. So in this particular case, we had location of a bus stand. Okay, changed by the RTA. The location of a particular bus stand was changed by the RTA. Okay, under Section 64A of Motor Vehicles Act 1939, it says, okay, an application could be moved against the order of the STA, okay, within 30 days from the date of order of the RTA, okay, within 30 days. So it was held in this particular case that while interpreting statutes of limitation, equitable considerations are out of place, okay, and clear grammatical meaning of the enactment should stand. So it has to be brought within 30 days, and it's more. So it's very strictly applicable in case of law that statutes of limitation. So this is something that we had discussed earlier as well, that when it comes to statute of limitation, the rule is that it has to be strictly adhered. No questions of justice, no other questions are to be considered. So we have another very interesting question, case. Okay, this case is very interesting and you will remember for a long time, because even I remember after so many years of studying this case. Okay, so this goes by the name Annapurna Biscuit Manufacturing Company versus Commissioner of Sales Tax. Okay, so under this particular, in this case, okay, particular section 3A of UP Sales Tax 1940 was under consideration, as it was back then. Okay, the state government issued notification under this act, okay, fixing tax at certain amount, okay, at 2% of the turnover payable at all points of the sale in the case of, okay, all these are not that important. So it imposes tax, okay, on what? On cooked food, okay. It imposes certain tax on cooked food, okay. The question was whether biscuits will come within the meaning of cooked food. What do you think? Do you think biscuits will come within the meaning of cooked food?
Yes, sir.
Yes, sir.
Yes.
Well, you see, that's where the problem is with this particular rule. So, see, if you go by in a very technical sense, well, that's how you understand it, okay. But when we talk about cooked food, we don't say biscuits are cooked food. But if you go by a very technical, understanding of it, obviously biscuits are baked. Well, what is baking if not cooking, okay? So, but then that's not how we understand what cooked food is, okay? So it was held in this particular case that it is a well settled rule of construction that the words used in a law imposing a tax should be construed in the same way, okay? So remember, this is a taxing statute, okay? So it was held, it is a well settled rule of construction that the words used in a law imposing a tax should be construed in the same way in which they are understood in ordinary parlance in the area in which the law is in force. So in that area in which the law is in force, biscuits are not understood as cooked food. Okay, that's what was held. So it says, if an expression is capable of a wider meaning as well as a narrower meaning, the question whether the wider or the narrower meaning should be given depends on the context. Okay, so if you go by the wider meaning, then obviously biscuits come within it, but the context does not allow. Okay, the legislation is in a specific area, and in that area biscuits are not considered as an example of cooked food. So it was held in this particular case that in the context, okay, and background of the notification, biscuit cannot be treated as cooked food. Okay, so that was what held in this particular case. Well, what about then? Okay, in all these examples that we discussed, we saw that, well, the courts did not go by technical meaning. Okay, it did not go by any technical scientific meaning. Okay, what about words that are technical? Okay, what about words that are technical? What are we to do in that sense, in that situation? So broadly, the rule is that if the words have a technical meaning, if the words have acquired a technical meaning, then technical words are to be used in that technical sense. Okay, so in a case by the name Union of India versus Garware Nylons, okay, EIR 1996, just a second, I will type it here. There are many other cases though, just examples. Okay, in this particular case, it was said that as a necessary consequence of the principle that words are understood in their ordinary or natural meaning. Now you see that ordinary and natural meaning is not that easy. So they say that in relation to the subject matter, in legislation relating to a particular trade, business, profession, art, science, words having special meaning is called a technical meaning to distinguish it from more common meaning that a word may have. Okay, so in those specific areas, it might have acquired a technical meaning, and it is to be used in that sense. Okay, it is to be used in that sense. So in this particular case, what did they hold here? They held that nylon twine was held to be included in nylon yarn. Now difference is, okay, if you go by very scientific definition, okay, what is the difference as I understand is that nylon twine would probably involve, okay, that nylon wires are like intertwined, okay. And nylon yarn is basically yarn as we understand, okay. So the question was whether nylon twine would come within the meaning of nylon yarn. It was held that in this particular industry, nylon twine would be considered technically as nylon yarn. So that's how it was decided in this particular case. Another important case that we have is by the name Atul Glass Industries Limited versus Collector of Central Excise. Many other cases are there. I would remind you, these are just the cases I thought I should bring here, okay. So see how the words have acquired a particular technical meaning in a particular industry, and that is the meaning which is to be assumed. So in this particular case, it was held that glass mirrors, okay, they are different from glass or glassware, okay. So glass or glassware have different meaning, and glass mirrors have different meaning. So they are not the same thing. That's what was held. But if you ask whether glassware or glass would normally, okay, or otherwise scientifically include glass mirrors or not, one might say that yes, but in that particular trade practice, they are considered different. So in this particular case, it was held that glass mirrors are different from glass or glassware. Similarly, in a case by the name Commission of, these are mostly taxation statutes, and in taxation statute, they apply strict rule of interpretation. And when we say strict rule of interpretation, they mean it, okay, because you cannot be taxed more than what has been intended by the legislature. And what is intended by the legislature, they are also assumed to be competent, and they're assumed to know the practices with areas in respect to which the legislation has been brought. So it is assumed that they know the specific meaning the words have acquired in that particular trade practice, etc. Okay, that's the understanding. So in this particular case, the question was, what is the meaning of manufacture here? Okay, so it was held that dross, okay, dross, you know, that outcome of, basically, what do you call it? When you refine a particular, what do you call it? Is it refine, or do you have other, words for it? I mean, when you use some ore of a particular, material, and then extract the pure, material out of it, then you are left with certain, waste, okay, and that's the dross here. So dross, okay, obtained in the manufacture of aluminium sheets from aluminium oxide, okay, whether it would come within the meaning of manufactured commodity or not. Normally, one might say that yes, it is. Why? Because it's a byproduct of manufacturing of aluminum sheets from aluminum oxide. Okay, but you know that in that trade and practice, this is considered as a waste. Okay, so this is clearly not a case of manufactured commodity. So will not come within the word manufacture, and hence it will not be considered as an object that can be taxed under certain laws. So that's the case, okay. I hope you understood. Another important rule, okay, is that the tense used in a statutory provision might have decisive effect. It's not saying that it necessarily has decisive effect, but we have cases where judges have taken it to extreme, okay. So for example, in the case of Mardana Mosque Trust versus Mahmood, it's a Sri Lankan case, okay. We'll just type it here. Okay, by the name Mardana Mosque Trust versus Mahmood, okay. So a particular act, okay, and a particular provision of an act empowered a minister to make certain order, okay. If he was satisfied that the school now here, okay, is being administered in contravention of the act. Now, what if the minister found that the school was being empowered, have been, like in the past, okay, administered in contravention of the act, okay? Will the minister have the power to issue those orders? It was held that because the statute clearly says is being administered, so any past okay, non-fulfillment of contravention of this particular act will not bring it within the purview of the power of the minister, okay. So an example, but not necessary though. So what is said is that tense used in a statutory provision might have, quite often does have, because tense would come within the idea of grammar, so have a decisive effect on the outcome of a particular interpretation of a provision. So that's it. That's your first rule. Okay, the first rule, that is literal rule. So see, literal rule seems to be very easy, but when it comes to application, it gets us into quite a lot of complication. But you see, the idea is this. Okay, we say that what is literal rule? We say that, well, what the literalist says. Okay, what is literalist? The words. Okay, words have plain meaning, and if plain meaning is what the judges are to assume. Okay, but then when there are certain trades and practices where the words have acquired a particular meaning, okay, and the legislation is with respect to that particular trade, practice, etc., then you are to use that meaning, that specific technical meaning. And if you have scientific meaning versus normal lay meaning that people understand, if the legislation is of such a nature in which we can assume that the legislature must have intended the lay meaning, then you go by the lay meaning and not the scientific meaning. So this is what we broadly studied. And apart from that, we also saw that if something is omitted, then the judge is not to read so as to include it. Okay, and if something is included, judges are not to omit it. Okay, so this is what we broadly understood and studied today. So do you guys have any confusions?
No, sir.
Okay, so
No, sir.
So go through these classes. These cases that I just shared with you. All these cases are available online, but these are not the only cases. There are many other cases. Okay, where the judges might have said something different to what we have discussed. Okay, but this is just for the sake of your knowledge. Okay, and in every single case that comes before the court, the context is different, and the judges might come to different conclusion. And that's exactly what this entire discussion, deliberation has been all about in jurisprudence. If you remember all those discussions, okay, that happened between Hart-Fuller, Hart-Dworkin, were essentially, and also the legal realists, were essentially about all this. That, well, realists would say that judges already decide a particular outcome in the back of their mind, then they give meaning to words, okay, to what is written in the provision, so as to justify what they already believe. Okay, whereas others disagree. So that's what all those debates have been all about, as you will see as we discuss further. So that's it for today. Okay, I almost ended up taking the whole class. No, not yet. I still have time. So anyway, spare me for today. Okay,
Okay,
so
sir. Bye, sir.
Okay, bye. I have anyone missing?
Thank you, sir.
Thank you, sir.
Asna. Anyone else? Okay, take care. Good day.
Thank you.
Thank you, sir.